welcome to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries. What happens in the road, work, medical negligence, we talk about everything. My name's Tony Carbone. I'm a personal injury lawyer of over 25 years experience. With me tonight I've got a partner in a law firm, John Karantzis. Good evening, John.
Hi Tony, hi viewers.
And James Richardson, a workers' compensation lawyer in a law firm. Good evening, James.
Hi Tony, hi everyone.
Tonight, viewers, have got a very interesting show. It's a work cover update. We're going to bring you up to date with the law on work cover.
However, Tony, before that, we'll get into what's in the news.
Well, John, the biggest story this week is the Hawks' fantastic grand final win.
It's a big win.
Oh, yeah.
Big win, Tony.
What do you reckon, James?
It's a great win for Hawthorn, Tony.
Look, the purple haze and all that nonsense I had to put up with all week, but looks like the yellow and gold took over.
And Gunston, he did the job, didn't he, for you, Tony?
And Brian Lake, all those...
yes.
We're not paying all this big money for guys like Buddy Franklin to go to Sydney, John. That's the beauty of it.
There's a bit of an issue there, isn't there, Tony?
Oh, I think so. It could bring the whole game into disrepute. What do you reckon, James?
Indeed, indeed.
The real problem, John, is this. They've got this 10% living away from home allowance, which is being used for the wrong reasons.
Yes.
You've got people like Eddie Maguire and Mick Malthouse, a Carlton coach, that's up in arms over it. What do you think is going to happen there, John?
The question is, Tony, he signs a 10-year contract, then the AFL say, oh, no, we're not going to give you that money. Well, Sydney's going to be stuck with that 10-year contract.
Well, the real problem, James, is this. It's a 9-year deal. If he falls over in, say, the 4th or 5th year, they've got to pay out his contract, James.
That's correct.
What does that mean? The club just folds, doesn't it?
That's correct. It's going to cost them a lot of money, Tony.
Well, they're going to have to get rid of a lot of players. But anyway, look, let's move on from that but viewers, go Hawks. Federal court sees a surge in work disputes. What's this about, James?
The federal court has seen an increase in psychiatric claims through the federal court, Tony. Essentially, there was a change in legislation and there's been a almost tenfold increase in
the number of applications.
That's right.
Tony, you're quoted in this article.
Yeah, I am.
And you talk about how hard the system under work cover workers have to make claims, and therefore people are now issuing in the federal court.
Well, John, one of the reasons why, as a lawyer, I'd prefer people to go to the federal court is because you've got a very experienced judge looking after the case, plus there's no juries. And you and I know that juries latch onto some innocuous things.
Can be tough.
Yeah. And the cases seem to go a lot longer when there is a jury involved. Is that correct?
Weeks, it doubles in time.
And James, what about the onus shifting back on the employer to show that their actions weren't adverse to the worker?
That's correct, Tony. The onus shifts in this jurisdiction, and it's much more favourable to the plaintiff.
And John, effectively what it means is that the employer has to disprove that their actions were adverse. Is that correct?
Exactly, Tony. And we've seen at our firm, Tony, we've been issuing more and more applications in the federal court at the Fair Work Commission because of this reason.
And also, John and James, you've got a situation where damages in the federal court are unlimited.
That's correct, Tony. Unlimited damages in the federal court jurisdiction.
Which is fantastic. Let's move on. Just on the issue of suing in a federal court or in the work cover jurisdiction, John, there's this article, WorkSafe Chief Executive Denise Cosgrove says that the number of claims have come down,
yes,
and the premiums in Victoria are the lowest in any state in Australia.
Yes.
What about the numbers of injuries? Have they come down, do you think?
That's an issue. The WorkSafe's net result for the last financial year, Tony, is over $1 billion.
Which is good for the system.
So the system is in great financial health. Let's hope the Victorian government don't get their hands onto that money and put it into
consolidated revenue.
General revenue.
Look, traditionally that hasn't happened. It's only been in the car accident jurisdiction where they've been taking premiums out and using them for consolidated revenue.
But the problem is, Tony, there have been 15 work deaths this year in Victoria.
Has. There's been another farmer die who got 84-year-old James.
That's correct.
Got slashed by his own slasher, which is,
And it's the 5th workplace fatality in 3 weeks.
Yep.
It's just too high.
That's right.
James, this 84-year-old is a bit old to be working on a machine like that, don't you think?
That's right, Tony. But I guess from the article, it indicates that he was working on his own machinery at his own farm. So,
I don't reckon I could use a hammer, let alone a slasher at 84, John.
84, no, it's a very dangerous thing what he's doing, and unfortunately he's been killed during the event.
Look, the sad thing about it, I guess, is that when you're dealing with the farm and the land, James, it's really hard to get help, isn't it? And
That's
plus, they're subject to the elements of weather, whether they get a good crop or bad crop, so they want to keep costs down, don't they?
That's correct, Tony. That's right.
What about this fellow that's working at the Melbourne Water Corporation treatment plant who works on a grate that slips with the water and all the foam that comes through, falls in, and there's an admission there that if you fall in, that's it. You've got no hope of survival. What's your take on it, James?
It's a terrible story, Tony. It looks like Melbourne Water has pled guilty to what seems to be criminal charges. And, you know, father of three, terrible story for Victoria.
And John, what about this allegation that if the grate moves and you fall in, that's it, you can kiss your life goodbye?
Where he falls in, it's the type of water where literally, Tony, you can't get out of. It's almost like sludge.
Yeah.
And it's such a dangerous workplace environment that there has to be further barriers put in place. And Tony, it's just another example that employers, big organisations and small, need to ensure the safety of their employees.
I guess you're working in an environment where it was really Russian roulette, wasn't it?
It is.
I mean, a grate lifts, you fall in, there's sludge, there's also a lot of water circulating. You got no hope of survival.
And
in fact, they have to drain it out, James, to find the body.
And that's
a
why
story.
the employer is being prosecuted by the Victorian Workcover Authority.
And now they've talked about putting up barriers and other things to prevent this from happening again. It's a bit sad after the event. When you're talking about an organisation that's as big as this,
Exactly.
they should have had the foresight to protect the worker.
That's correct, Tony.
Anyway, it's a sad thing for the family and the rest of people working with him. Hospital shock. The staff at the Epworth are saying they're getting a lot of electrical jolts from working in the place. Does that mean that their electrical system is out of date? Who knows? What do you think, James?
Could be, Tony. I mean, look, the article reports that the Epworth had the site tested on numerous occasions and that it was deemed safe. However, there have been numerous reports of similar instances.
And John, you've done quite a few cases involving people getting electrocuted.
Shock. Yes.
How severe are the injuries?
Yeah, look, it could be debilitating, Tony, to the worker. A little electric shock, and there's really no such thing as a little electric shock, because once the voltage, the current enters the person, perforates the skin, it could damage the nerve system of the particular person, that worker. It could take years, but you find instances where their spine has been disintegrated, hands are not able to be used, the whole body can shut down, Tony.
Also brain injuries and other things, isn't that correct?
That's right, Tony.
Viewers, we've got to go to a sponsors break. Stay tuned. After a break, we'll go to the update on work cover. Viewers, welcome back to the show. Tonight's episode is very, very important for people who've been injured in work circumstances because it's our work cover update. John, the firefighters' fury. There's been a bill put to Parliament to try and make it easier for firefighters to claim. People like those that were injured at Fistville.
Yes.
The vote went 2018 against. What's that all about?
Tony, the state government, the Liberal state government, did not support this Greens bill. It was in essence to help the firefighters, all firefighters that have suffered cancer-related medical conditions and injuries, particularly at Fistville. Covers all that to make the claim easier for these firefighters. Unfortunately, Tony, the state Liberal government elected not to support the bill.
James, the vote was 20 to 18, so it was a very closely run vote. Do you think it was a good decision, or was it a policy decision? What was it?
No, it's a terrible decision for injured parties, Tony. We still have common law rights, of course, but this decision stops the automatic right to compensation for those who are injured.
James, you act on behalf of quite a handful of Fiskville people that have been injured at Fiskville.
That's right, John.
What's their response been?
Well, John, we've had to issue proceedings in the Supreme Court, which is a long process, as you know, and you know we do have a large number of clients who have been affected by cancer-related injury.
One injured firefighter, Tony. He telephoned me just last week, just in tears at this decision. Now,
Well,
and he was a Liberals voter for the whole of his life.
Look, it affects about 60,000 firefighters, which is obviously a policy decision by the Nationals not to vote in favour.
Look, we all know.
A lot of money, John.
We all know it'll cost the government a lot of money, and they've probably done the math and looked at it and said we can't support this on the math. However, Tony, we've got injured people.
Yeah, look, it affects all their families too, because essentially you've got people here that could die of cancer. They're severely debilitated in terms of what they can and can't do. So it affects enjoyment of life and everything else, doesn't it, James?
That's right, Tony. We've got a number of injured parties at our firm who are suffering because of these related injuries.
At the same time, you still have a claim. You have to show on the balance of probabilities that you suffered injury at this workplace. And as long as the medical evidence, Tony, supports that, you have a claim.
Well, James, there's going to be, exactly, John, there's going to be a lot of other witnesses to assist these people pursue their claims, because there's more than one person at any one site that's been injured. So that goes
Tony.
a long way to tipping the balance of probabilities in your favour. Is
That's
that correct?
That's dead right.
The problem being that, as we all know, cancer-related type injuries is pretty difficult to show where it arose from.
Yeah. Although the fact that there's so many of them does assist.
Oh, yes.
Yeah.
Oh, yes.
Can we go to this case that was recently decided? It got to the Court of Appeal, but the original decision was down in the County Court. It's a matter of Elsko and Mercevich. James, can you give me the facts of this case?
Yes, Tony. This is a Victorian Supreme Court of Appeal matter. Essentially, the injured party was a laundry worker, and she described her work as heavy and repetitive in nature, and she developed a condition called cervical dystonia. In essence, the injury itself was not in dispute at the county court, but the causal link between the injury and the work that she was undertaking.
Well, let's get this right, James. The court and the defendant in this case was satisfied that the injury was serious. Is that correct?
That's correct,
Yes.
Tony.
So the issue in this case, John, was did the work causally contribute to her condition?
Exactly, Tony. Cervical dystonia. It's a genetic condition that's it's not well known in the community. The plaintiff, the worker in this case, alleged that due to the repetitive nature of her work, particularly the use of her neck and always twisting her neck whilst working, that aggravated her cervical dystonia condition. That was the claim at court, Tony.
Well, it's a nasty condition because
it's
apparently, in this particular plaintiff's case, she had spasms in her neck that caused her to turn involuntarily to the right.
Exactly.
So in effect, you're like this and your whole neck's moving. And apparently it's a very common condition in musicians. And that assisted us in proving the causal link.
That's
because
correct.
we ran this case. Now, take us through these doctors' opinions, John. Dr. Evans, treated neurologist, he essentially said that he saw 5 patients a week with this condition.
Yes.
And they were working in environments where the
repetitive type activity, Tony. That's the key. And he gave evidence. He's the expert in the area, Tony. The judge acknowledged that. and he supported the view that in this instance, it was probable that as a result of the work Vika Mercevic was performing, that her genetic condition of cervical dystonia was aggravated by her work duties. And that aggravation, Tony, in itself, the court found, was a serious injury.
Well, it just shows you that you take your victims as you find them.
Exactly.
She was susceptible to this condition coming on. That's what the doctors have said. Isn't that correct, James?
That's correct, Tony.
And the fact that she did this repetitive type work and was more prone to getting it because of her genetic makeup, it's irrelevant as far as the law's concerned. Is that correct?
That's correct, Tony.
Tony, it's interesting, the Court of Appeal decision had to examine the county court's finding in favour of the worker. And in particular, one of the grounds of the appeal, Tony, was that the judge preferred the oral testimony of the medical doctors as compared to the doctors that didn't give evidence, as in that were just simply relied upon by, in this instance, the defendant at court on the papers. Now, the Court of Appeal said straight out that there's no issue with that. Her Honour gave reasoning, gave a pathway of how she found her decision, and she preferred the oral evidence as opposed to literally the paper evidence. Just goes to show, Tony, having your doctor present evidence at court is really...
Well, John, it was a miscalculation by the defendant because, James, in that case, the plaintiff doctor that gave evidence was given a notice to appear for cross-examination.
Yes.
That's right.
So, in effect, by the plaintiff doctor coming along on this notice, it improved the plaintiff's case.
Arguably, it tips the balance of probabilities, Tony, in favour of our client. So it's a great result.
James, the defendant banked on the plaintiff doctors shying away from their diagnosis.
Conceding what they'd written. Interestingly, Tony, the Court of Appeal found in favour of the worker in the sense that, yes, we cannot touch the decision of the county court, as literally the reasoning was fine.
We'll come back to some finer points after the break, guys, because we've got to get our sponsors break. So, viewers, please stay tuned. Viewers, welcome back to the show. Before the break, we're talking about this case of Mercevic. John, do you want to summarise what's happened now?
Tony, the Court of Appeal has confirmed the county court's decision that the worker suffered an aggravation of her cervical dystonia. The matter now is under negotiations with the Victorian Work Cover Authority, Tony. She's entitled to weekly payments, compensation, and a lump sum compensation for economic loss and pain and suffering. We hope
Common sense prevails.
Common sense prevails. Otherwise, unfortunately, it'll go back to court, Tony.
Exactly. And James, surprisingly, the defendant did accept liability for the injury in the first instance and paid a weekly payment for 6 months. And then all of a sudden they had a change of heart and said, oh, no, we're not paying it anymore.
That's correct, Tony. So the weekly payments were paid for a limited period. Then they were terminated by the agent. Of course, the fight will continue for those payments, Tony.
Exactly. James, I'm going to get you to give us the facts of a case of Meadows and Lichmore. It's a recent decision in the Court of Appeal. Do you want to tell us a bit about this case?
Sure, Tony. That's another Victorian Supreme Court of Appeal matter, disputing essentially a rejection of a serious injury claim. The worker was a factory worker, picker and packer, and suffered what's called lateral epicondylitis of the arm or tennis elbow. Essentially, the serious injury application noted pain and suffering consequences that fell between what's called psychological and physical injuries. Unfortunately for the claimant or the worker, the claim was rejected on the basis that the pain and suffering consequences were not disentangled at the time.
Okay. Well, John, my understanding is that the plaintiff's lawyers took it to court on a physical basis, physical injury.
Exactly, Tony.
And what's that all mean?
It's a serious injury application for lump sum compensation for pain and suffering and economic loss. The worker in this instance, it's a female, she's suffering from literally tennis elbow. Unfortunately, there was mixed medical evidence, wasn't there, Tony?
There was.
Some doctors were saying it is physically based, as in organically based, the injury, but other doctors were saying, oh, there's a lot of psychological issues here, pain syndrome. Tony, unfortunately, the use of the word chronic pain syndrome, I don't like it because literally a lot of doctors, when they say that, it means we don't know what's wrong with her.
Well, the problem with this case is that she started off with what was a physical injury because she also had a tear in the elbow.
So that's clearly a physical injury.
And in time, it became more psychological,
Yes.
the chronic pain component to it.
Yes.
So is it a case, James, that maybe the lawyers should have applied for psychological as well?
That's right, Tony. If the lawyers had added a physical and a psychological component, then the disentanglement would not have been such a problem.
But the problem here is that under the law, if you want to succeed on a physical injury, you have to show physical consequences. Here, there were psychological consequences. As you rightly were saying, what you have to show then is a separation between the physical and the psychological consequences, and that there are psychological consequences that have nothing to do with the physical. But the problem here, Tony, wasn't done, was it?
No. But the thing is this, John. The Chief Judge in the Court of Appeal, Justice Maxwell, said it's a two-step process.
Yes.
He said the first step is whether there is a substantial organic basis for the pain and suffering consequences that are relied upon, James. Now, obviously the court thought that the injury, it wasn't substantial from a physical perspective.
That's right.
So once you've gotten past that, the next step is, okay, apply for a serious injury based on psychological consequences. And then you have to disentangle that part of it that's physical as opposed to psych.
That's correct, Tony.
And you've had to do that a few times. How complicated is it?
It is difficult, Tony. We see it a lot certainly in the work cover practice, don't we, John? A lot of our clients do have an organic basis for their injury when they first come to see us. But by the time we get to court, there is what's called a psychological overlay that does complicate things.
Or a chronic pain syndrome.
That's right.
But the way to disentangle that is for the medical evidence, as in a psychiatrist, and the treating orthopaedic surgeon to say, in regards to the psychological claim, this is the psychological component of the injury, and then you have the treating orthopaedic surgeon say, this is the physical component of the injury.
And James, if in doubt, don't you use the shotgun approach? You go physical and psych?
That's right.
Yes.
That's right. And it's our practice, isn't it, John?
And John, you've seen plenty of these. I mean, realistically, picking your lawyer is pretty important.
Tony, you need the right lawyer to really go through the evidence, go through the medical evidence to make sure that the claim is sound, that you're not going to have these disentangling issues. Judge O'Neill of the County Court, there's a lot of judges in the County Court that will look upon this straight away. They're experienced, they know the system, and the judges want us, the worker, to show that you either have a sound physical injury or a sound psychological injury. You can have both as long as they're both serious, Tony, correct?
Exactly. Well, can I ask you this question? The diagnosis in this case was for a moderate common extensor origin tendinosis with small intrasubstance tear. If you had that diagnosis, James, and someone complaining profusely about pain, would you have gone psych as well?
Depends on the case, Tony, but
And I'm not talking hindsight now. I'm just saying.
That's right. The injury itself is an organically based injury, so most certainly I would have put that down as a physical injury. But certainly if there was a psych overlay, you do need to be able to distinguish between the two.
Okay.
So
well, John,
you'd
to
claim
take it
the
one step further, there was a lot of doctors in this case saying that she had chronic pain. She was not exaggerating, but she was complaining a lot. The alarm bells start ringing, surely.
And Tony, as long as that psychological element was as a direct result of the work injury, then you would claim it.
Exactly. Look, I would have gone both limbs, and I'm not talking hindsight.
I agree.
Because I think it would have been safer.
I agree.
Is there anything else you want to add, John, because we're getting towards the end of the show?
Tony, just in work cover claims, viewers, you do have entitlements when you're injured at work. We recently settled a claim for a 66-year-old lady, had back surgery, minimal complaints, Tony, but the work did cause the injury for $250,000. Now, for this lady, it's heaven sent for her, Tony.
That's exactly right.
And she suffered a really nasty injury. It's settled prior to court, Tony. Just goes to show that, the Victorian Work Cover Authority, they do want to talk when there are real injuries.
Exactly. James, anything else you'd like to add?
No, that's it for me.
Go to our Facebook and Twitter page. Also, go to past episodes, future episodes. And remember this, viewers, you don't need to spend $10 million to win a premiership. The Hawks recycled Brian Lake, Gibson, Gunston, Burgoyne, you name the list. Just shows that good list management will take you a long way. A bit like any other business you run. Anyway, on that note, stay tuned and stay safe.